Abisuane ahwefo I daily update TV so say na o hwe ya ye be mo akwa abaso koso say obe subscribe ya my YouTube channel o do comment abese o kire wadwen akwan bi o ho abetima kire wadwen be kenkan so ama ahwefo na tifo nso ehu bi na abusua this week as last week like Friday, Good Friday precisely anama me Torkono former Chief Justice her leadership okofale eye suit ewo Accra High Court na the woman nyina ne say what they stop the appointment vetting committee Justice Poaman Edano omo be vete eye Justice Bonnie na dem say wababa be ye Ghana ye justice penyini pa on beda ye justices for ni nyina no na abusua na according to Emran say we article 146 procedure yedi yi maame Torkono article 146 na article 146 no kenkan a ma woti ase detail ma woti ase said o mampanyi receive petition bi na or refer ma council of state o mo behwehwem na o mo hwehwem no mo determine prima facie case na je ho no o mampanyi Emran mo mampanyi kwase onti committee na o mo nya asem ni hwehwemu na say asem no omo ye hwehwemu ya recommendation ebeba no the president shall act on a recommendation so empemfo ehwehwe nkrata mu investigations sana omo establish the letter na bra mampanyi act on it and yi na di na abusuya maame Torkono se onte ne ho ase because procedure no na adwem no susu se niema bi ankoye anase niema bi ayede ball no kwadu bi yede ball no ohwemu wie a enne no pressure nti no wasa ko high court se eno akofale the appointment committee yate a omo behwehwem na omo aveti yura Baffoe na afi omo amana be the Chief Justice of the Republic no wafale suit ana kwamina asasale ebusan se kemeni busan se so ebetimi aye possible no se de ontimi and stop the process okokoto this will not stop the process abusan yemfa credit ma TV3 nengotie lawyer and sansar former Ghana School of Law in Semana Oka.
You know, humility appeals to the president, but you see, he doesn't appear to have learned any lessons from what has happened. He has become too abrasive and an irritant now. His reputation this is now rising. And I think that if she has friends who love her, they should advise her to stop what she's doing.
I see. So, as far as you are concerned, as far as you are concerned, these legal processes cannot stop the vetting of Baffoe.
How can it stop?
Very well. The other thing I want you to clarify. The other thing I want you to clarify, Counsel, is legally speaking, is she not able to challenge the decision of the committee's decision on her?
We are done with the committee. The moment the president accepted the recommendations contained in the report, whatever the committee did, whatever the committee said, please to be the act of the committee. Now, because the president has acted, it is now presidential. So let us stop talking of the committee and rather, talk about the president's decision.
Very well. So let me rephrase the question then.
Finality on the matter.
So I'll rephrase the question. Legally speaking, is she not able to challenge the president's decision to remove her after the facts?
It is devoid of constitutional support. It has no support under the Constitution. Article 146, clauses 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and 11 don't support any such cause, I'm afraid. Because nowhere in the 11th clause has it been mentioned that after the president has acted on the report of the committee, it can be liable to another determination. No, there is finality, and once the president signed the signature sealed the case. So that determination was conclusive of the matter, and it cannot be reopened. This afternoon I said that the door had been shut. The key had been taken away. There's no window through which you can enter the presidential lounge as far as this matter is concerned. So if I were leadership Torkono, I would rather find an amicable way of coming to an end of this matter. It's not showing any humility. He has to approach this matter and realize that he is dealing with the president of the republic. So this you think you are president, you wait and see. I was a former chief justice. Is he going to how long is he going to continue this? Is he going to continue until she turns 70? So that she will go down in our history, in our records, as a former chief justice who refused to abide by the president's decision.
I see. So, Lawyer, I've heard you say an amicable solution a number of times. What does that look like? An amicable solution?
You see, we have a council of state. We have a judicial council. Let us, not forget the fact that they are saving there. There are many of them, most of them are men of the world, women of the world, imbued with wisdom. At least the president cannot pretend that he doesn't have friends among membership of the judicial council or the council of state or even among the clergy. So what he should have done was to have appealed to the conscience, the good, the PG removal process, pursuant to Article 146. But however, I think that as far as my removal as a justice of the Supreme Court is concerned, I wasn't given sufficient opportunity to be heard on that. And therefore, if you can reconsider or review that and retire me so that I can at least, enjoy my retiring benefits. But the very aggressive and abrasive poster that he has, launched against the president, I don't understand. I have spoken several times. I have advised her several times. Please, you can't fight officialdom. Therefore, find a way. Go and appeal, through some people to the president. He's a human being. He's the father of the nation. He will listen. But I think he's going to ECOWAS. Very soon, he'll go to United Nations. And then another one. But the truth of the matter is, all authority is divine. If the people have spoken and there is some truism in the biblical assertion that the voice of the people is the voice of God, then if the people have spoken, God has also spoken. He's a Christian, and therefore Scripture has taught us some useful lessons that we live our lives by. And one of the scripture lessons is that we should know when the end, is time. Once you get to the end of the road, don't ask the dilemma of a goose. Where should I go? Should I go to Cape Coast or Egbina? Here, she must respect the Constitution.
Indeed, lawyer.
No two questions about that.
Lawyer, we'll end it here, but thank you so much once again.
How the other issues have panned out. You do recall that as far back as May 2025, that was the first time she herself, a writ of summons in her name. We had seen some previous 3 attempts at the Supreme Court, but they were not in her name.
Right.
But this May 21 was one that was in her name. Subsequent to that, she filed an injunction to stop the process. That was when the committee had started its work. That injunction application was unanimously dismissed. Then fast forward to June 2025, there was a judicial review at the High Court, which was dismissed. This judicial review was to the effect that the processes before the committee were infringing on her rights, for which reason she wanted the court to intervene and stop. But the court dismissed this particular application. In July 2025, she filed a case at the ECOWAS Community Court in respect of the proceedings that were before the committee. And this matter is still pending because there was a point where they had to determine some preliminary matters, which we have always explained, the kind that would be the same as injunction applications in our jurisdiction.
Right.
The court had to adjourn indefinitely to make a ruling. That is still pending. So we still do not know the outcome of that particular matter. Again, in July, there was also a judicial review again, which was seeking to declare the Shining Stars of Ghana, one of the petitioners, as non-existent in fact and in law. That application would later be not withdrawn. There was an attempt to withdraw by her lawyers because at the time they had gone to hear it, she had already been removed. So there was an attempt to orally withdraw from, but the court refused. That this was a process that was duly filed, so they should come proper, meaning they should file another process to withdraw it. We've since not heard about that application. The 6th one was an application that was filed, not a writ of summons, at the Supreme Court. This time around, she was challenging her removal as the justice of the Supreme Court. Her contention in that suit was to the effect that, yes, you have removed me as the Chief Justice, but I should still be allowed to continue as a justice of the Supreme Court. That matter is still pending before the Supreme Court. Now, today we are learning that she has filed a new suit at the High Court, this time around, seeking to quash the Justice Palmer's proceedings, committee's proceedings, its outcomes, and also to halt the appointment of a substantive Chief Justice. 7 lawsuits in all, gearing towards her removal and seeking that, the point she essentially makes is that all the processes that she's gone through, they are unlawful. They should not have, she should not have gone through all that.
Even in this new challenge?
Yes, in this new challenge. And just to point out a few things in this particular one for you, especially in respect of the matters that she raises, she talks about some 3 reasons that the committee recommends based on which she was removed. She says the committee gave 3 reasons. In fact, one of the reliefs is that those 3 reasons should be brought to the court for them to be quashed. Now, what were the reasons? She reproduces them. It had to do with the travel expense of the Chief Justice. She was alleged to have gone on some travels that she was not entitled to, and she got some monies. That's one. The second one has to do with transfer of a judicial officer by name Mr. Francis Baden. And the third one had to do with a recommendation of some judges for consideration for elevation. This had to do with some judges who were recommended to be appointed to the Supreme Court. Now, these are the grounds for her argument in respect of these 3 reasons that she talks about. So she makes reference to the first one, that the first finding is false. That is the one that has to do with the travel expense. That the first finding is false, misleading, irrational, and illegal because it cites misconduct for expenditure that was neither disallowed nor surcharged by the Auditor General. So she mounts her argument on the Auditor General's report, and she says that this expenditure for which the committee says that she had done something wrong was neither disallowed nor surcharged by the Auditor General. Still on that point, she argues that the first finding is also unreasonable and unfair because it attributes unauthorized expenditure to the Chief Justice, though she neither authorized nor administered it, essentially saying that whatever monies were paid to her, she was not the one who authorized it, or she was not the one who paid such monies.
And some of these arguments, Dennis, have been made before in the past, in support.
In separate fora.
Absolutely.
Yes, so now she's appearing before the High Court in respect of this judicial review. These are the grounds on which she's coming. Now, the third one, this addresses the second issue,
right,
and then the appointment itself. But she says that
even the consideration too
should be put on hold.
Right. And this coincides with a petition that had come up earlier against the acting Chief Justice.
Yes. So there's also that petition, except not much has been heard about it.
Indeed.
Only to hear that the petitioner himself has indicated he submitted that petition to the presidency. But usually when those petitions are submitted and the presidency will acknowledge receipt and make communications on that. We haven't had any communication on that particular one. It's not the only person. His Lordship Justice Yoni Kolendi, there's also reports of another petition in there.
Absolutely. It sounds like a hot mess in the judiciary at this time.
Precisely.
Is there anything else you're sharing with us tonight?
I mean, that will be it for now on this particular matter because we're still having to deal with quite a number of legal matters because we're in court today. It was a busy day in court.
Indeed. But even before we go to the other legal matters, Dennis, we know that Austin Bracco-Powers, private legal practitioner, has been reacting to this latest development from the Chief Justice. Let's take a listen to him. We'll come back and then have a conversation of that as well. Don't go away.
If you will notice, if you follow the trajectory, you will notice that this is part of the checklist of the Chief Justice to bring sanity and to make sure that the right thing is done. I have said in the beginning, the processes triggered to get her out had issues. And I think she's just trying to get the right thing done. We should not falter because whatever she's doing for the entirety of Ghanaians so that tomorrow someone else who may be given the opportunity to occupy that particular office will also benefit from her work. I think she's doing the right thing. Even though she believes that the president has a constitutional duty under Article 146 to set up a committee, she believes the right thing must be done. And for me, I think this is the right process she must do. We need to get to the bottom of this. The fact that she had been given a warrant of removal should not bring closure to the matter. We must get to the bottom of it, whether the allegations, so-called allegations made against it. In fact, if you've read Action, the suit she just filed, you will notice a lot of things, a lot of claims that she has made, which for me, if those claims are anything to go by, it's those claims raise key questions about the work of the committee, the Article 146 committee. And for me, any court interested in justice, interested in making sure that justice is not only manifestly seen to be done, but justice is done, would have to go into this matter and deal with the matters as they are until we get to the bottom of it for everybody to be settled with that, whatever outcome we may have.
Austin Brown is a private legal practitioner. Let's now connect with Director of the Ghana School of Law, Kweku Ansasare. Lawyer, good evening to you and thank you for staying up for us tonight. Now, what Bracco-Powers is saying is quite contrary to what you have told us. In fact, you have described the action as, or her and her action as irritant. And you have said that the seat of the Chief Justice is not a traditional stool. Why?
It is true that the office of the Chief Justice is not a traditional office. It is an office created by virtue of a constitution. But what is happening now, the former Chief Justice seems to be personalizing the issue. Now, my reaction to demand now that the president should have nothing to do with the anticipated vetting of for Baffoe, is laughable. It just reminds me of what, the old days just before Nanado President ex-President Kufuor came to power. Mokwaya, Imokwaba, that's all. I mean,
na busuami Torkono asɛm no na emanfo bebre kase nka na nka openie a anka ono ankasa mfiri ni pem no anya den on resign said den sabeka ne benefits ni entitlement bia ebetumi aboa no ewo na homegye mu na things nipa bebre etu ne full of late but afutu ni nyina eche no maame na pressing on maame Torkono pressing on say use the legal procedure na or the iden or the atoto niema na ebusua ni nyina ne say legal procedure ni nyina echi no or the court ni abona or the court ni reject or the court ni dismiss it saa kopim say committee no eye ne hwehwe mu wie ya omonde esakine from officer Friday or Safali because article 1 for said the president receive petition unreferred to the Council of State. If the Council of State establishes BBF and prima facie case, then they proceed ahead to form a committee. In the committee, no mono and obeko na ya tutuna no ni investigate no and sema omudi teme no no kre we no kre we anya no kre na ne nyina echi no emwaye committee no baba eno na omampanyin edibedi juma. Enti committee ni yes niama we nyina make sure say omode eniema begu akwam ama eye nokre ni pepepe adedi na eno na maame Torkono still on tin one say there be eniema bi as ye bunkam niema bi ayere egunu so ana say eniema bi entwe yi enti or the ensem na sa akodan Accra High Court say monhwe na montutu monhwe niema ni mu ye no no onti bibi ase obusua me de obesi ase na share dwumadi no like never comment show man. God bless you.